Hi, I'm Chuck Panzarella. I'm the founder and managing attorney at Consumer Action Law Group. And today we're going to talk a little bit about an issue that's pretty common, sadly, when a dealer lies or doesn't really tell the truth about a car with previous damage. In this case, we're going to talk about frame damage. So I'm going to walk you through how this issue comes up, and then we're going to loop in Matt. We're going to talk about a recent case that we came across, but again, this is a pretty common issue. Essentially what happens is someone will go to a dealer, they'll buy a car, the dealer will usually tell them it's a clean Carfax, there's no sign of any previous damage, or maybe there's minor damage. They'll tell you that the bumper was scraped in a parking lot. And then later, buyer will go, this can be even years later, they'll trade it in, or sometimes they'll go to Jiffy Lube and look under the hood. There's some paint in there. You can see the car has been painted, oversprayed. Usually what happens is it's gone through a body shop. That paint looks different than the original paint. And they find out by pulling another Carfax that in fact there was serious damage. It's called frame damage, where the frame is bad. They can be fixed, but usually it really hurts the value of the car. Sometimes it can hurt the safety as well. We're going to walk you through a recent case that came in, and we're going to loop in Matt. He's one of the lawyers that we work with. Matt, maybe you can walk us through what happened on this case recently.
Sure. Thanks, Chuck. My name is Matt Failer, and I'm an attorney here at Consumer Action Law Group. And we had a recent case where a customer, our client, bought a BMW in San Diego in 2021. While she was in the process of purchasing the vehicle, she asked the dealer salesperson, was this vehicle in any accidents? Did it have any structural or frame damage? To which they told her no. Based on that, she decided to purchase the vehicle. So she drove this BMW for about 3 years until earlier this year when she went to go trade in the vehicle to get a new car. She found out the vehicle had structural damage, to which she had no idea. This prevented her from trading in the vehicle because the dealership that she was trading it in at would not accept vehicle structural damage. Wisely, she reached out to us and we were able to take her case. So we went through the general process we do when we handle structural damage cases. We first sent a demand letter, which is required under the Consumer Legal Remedies Act, which we sent to the dealership in San Diego. In this particular case, they did not respond. So if they don't respond, then the next step really is filing a lawsuit in Superior Court, which we did do. When we filed the lawsuit, the dealer retained counsel and they reached out to me and said, oh yeah, the vehicle did have structural damage. Yes, we didn't disclose, and we will buy the vehicle back. They agreed to take the vehicle back for all our clients' payments over the last 3 years. We paid our attorney's fees, and our client got her money back out of the vehicle. We got paid. Everyone was happy.
Just to recap, some of the common questions we get: how long do I have to file a lawsuit? What if it's been 3 years since the damage, since I bought the car? What if it's been 5 or 6 years since the prior accident happened? As Matt said, we can usually take a case based on when you find out about the damage. If this is something that happened to you, if you call us, we can walk you through it. Another thing to circle back to, let Matt handle this one. What if the dealer does respond, but if you try to take it back and the dealer says, yeah, you know what? There are a lot of disclosures and you signed a lot of forms, and one of the things you signed is a Carfax. And that's another common issue that we run into, where they say, yeah, we told you about this. Matt, has this come up?
Yeah, there are situations where we'll have clients who go to trade in their vehicle and they find out about an accident or frame damage, and then we proceed and it's a demand letter and/or lawsuit, and the dealer will provide us disclosure documents. Those can be very challenging sometimes because they often have what appears to be our client's signature, indicating that a judge or an arbitrator might in fact believe they was actually disclosed. But there's a lot of case-dependent circumstances that might render the disclosures less effective. So it's important that even if you have a document which purports to disclose damage to you, that you talk to an attorney about it.
So to recap, if you find out that a dealer lied to you, it can be years later, it can be prior accident, it could be odometer rollback or flood damage, it could be a number of things. Maybe you find out that there was an engine in there or aftermarket parts have been installed, and you thought you were buying the original engine and the original parts. But whatever it is, if it comes to light later, best bet is to call us, Consumer Action Law Group, talk to one of us. We will look at the documents and we'll figure out if you've got a claim. And we're here to answer any questions. It's 818-254-8413. And we'll talk to you soon. Thanks.